जब तक 7 फेरे ना हो जाए तब तक शादी नहीं मानी जाएगी in Hindus. This is not what I am saying. This is what the Supreme Court has said in the recent Supreme Court judgments regarding Hindu Marriage Act 1955. What has been the issue? We will be understanding each and everything, but before that, let's go to basic. Let's understand from where it is coming. What are the rules, regulations, and what are the act says regarding this? So this has been in the news. Recently, Supreme Court has given a judgment. We will be coming to the judgment and coming to the issue, but before that, we should restrict ourselves to the concept. So to formalize everything regarding marriage in the Hindus, the Hindu Marriage Act 1955 was passed. It codified the law regarding the marriage in Hindus, and not only Hindus, but this Hindu Marriage Act 1955, it encompasses other sections also. For example, Arya Samajists, Sikh, Lingayats, Buddhist, Jains, right? So using this Hindu Marriage Act, all this community can also have a marriage ceremony. Okay. There is a special section, section 7 of the Hindu Marriage Act, and which says that the ceremony for a Hindu marriage, what kind of ceremony should be there in a Hindu marriage to be solemnized. So a Hindu marriage may be solemnized only if it has been performed using the customary rites and ceremonies, right? And in these customary rites and the ceremonies, there will be inclusion of the saptapadi, 7 फेरे जो आप लेते हो, the sacred fire के around 7 फेरे लिया जाता है, and it is said that the marriage will be assumed to be complete and binding only if the 7th step has been taken. तो ये बहुत ही ज्यादा इंपॉर्टेंट होता है इन हिंदू मैरिज, राइट? Beside this act, another act is there, that is a Special Marriage Act. Unlike Hindu Marriage Act, it does not cover Hindus only. It is not restricted to the Hindus only, right? It covers any men and women irrespective of their race, caste or creed. So, for example, if intercaste marriages happen, if inter-religion marriages happen, then that can happen through the Special Marriage Act 1954, right? And now you will ask whether this same sexual marriage, whether it is allowed, can that happen through the Special Marriage Act? No, that cannot happen, because the Supreme Court had said that the right to marriage is not a fundamental right, and it is still saying that the homosexual marriages are not allowed in our society. So that will not be coming under the Special Marriage Act, because to have a marriage, a man and woman has to have. In a homosexual, either it is man and a man or it is a woman and a woman. So that marriage cannot happen through the Special Marriage Act 1954. Then one important provision of the Constitution is there, that is Article 142 of the Constitution of India. It provides a special power to the Supreme Court of India. What kind of power? Through this Article 142, the Supreme Court has the power to pass any decree or order which is necessary for doing the complete justice in any case or matter pending before it. So whenever the Supreme Court feels that there has not been the complete justice, then to do that complete justice, the Supreme Court may use this extraordinary power under Article 142 of the Constitution of India to have this complete justice. And in this case, the Supreme Court has used Article 142 of the Constitution of India, right? So coming back to the issues, what has been the issue and why the Supreme Court has given such judgments, and what has Supreme Court has said while pronouncing this judgment, right? So actually what kind of issue is happening? Nowadays, the couples, before marriage, they start talking, right? And they have the plans to go abroad for the honeymoon, or if the husband or the wife is NRI, then they have the plan to go to that country after marriage, right? So therefore, for going to that country in a couple manner, in a couple fashion, they will need some kind of document, right? So before the actual ceremony of marriage happening, they will be applying for these documents, right? So they will do some kind of court marriages, and this is what happening. But many a times what happened, that after the court marriage happened and the couple started meeting each other and they started talking each other, so their differences occurred, and before the happening of actual ceremonial marriage on the basis of Hindu Marriage Act or on the basis of those customs and traditions, they want to get separate, right? So they want divorce, and this is what this case is also there. So on the 7th March 2021, there was a couple. So this couple got engaged to be married. On the 7th July 2021, they claimed to have solemnized their marriage, means they claimed that their marriage should be legalized, and a marriage certificate from the Vedic Jan Kanyal Samiti was provided to them. Using that marriage certificate, the couple has got the certificate of registration of the marriage. So actual ceremonial marriage has not taken place. Actual Phere has not taken place. They were living separately, and within some time, they felt that they are not appropriate, means they are not made for each other, and therefore they wanted to have a divorce. The marriage date was scheduled on the 25th October 2022, but before that only they wanted to get separated. Therefore, on the basis of this marriage certification, they filed for a divorce, and this is when this matter reached to the Supreme Court, and the Supreme Court has to give verdict on this regarding Hindu Marriage Act 1955. Right? What does the Supreme Court has to say? The Supreme Court says that the Hindu marriage, it is a sanskar or it is a sacrament, and a sanskar or the sacrament cannot be accepted under the Hindu Marriage Act if it has not been performed using proper ceremonies. There has to be all the ceremonial functions performed before a marriage has to be solemnized, before a marriage will be legalized, right? So that is the Supreme Court said. The Supreme Court also said that do not just understand that marriage is about the songs and dance and the DJs and the long list of buffet you are putting, right? The long list of guests you have, the long list of the exchanges of the dowry and the gifts you are having. So this does not constitute marriage. Merely winning and the dining does not mean that the marriage has been solemnized. Marriage will only be considered solemnized as per the Hindu Marriage Act if it has been done using the proper ceremonial function, proper cultural function. Right? So that is there. Supreme Court says that a marriage, it is not a commercial transaction. That you will be putting that I have brought this much, booked so large hotels, so then our marriage has been performed. So that is not the case. It is not about the commercial transaction. Actually, marriage, it is a culmination of two families, right? It is culmination of two souls. It facilitates the procreation, because after the marriage you can have a legal child, right? So that is possible. It consolidates the family and it solidifies the spirit of the family, fraternity. So all these things are happened, and this is a one-time process, but for the lifelong. Once you get married, it gets continued for the lifetime, unless and until you get divorced. So So that is happening, and within a marriage, both partners are equal. Supreme Court even this said that there is no partner above or below, right, in rank. There is no hierarchy here. Everyone, both the partner is completely equal in nature, right? They have the equal status in a marriage. So this is what the Supreme Court has to say. The Supreme Court said that if merely this whining and dining marriage nahi hoga, unless and until you have performed the ceremony as per the section 7 of the Hindu Marriage Act 1955, the marriage cannot be said as the complete and it cannot be validated. Even if you have got the certificate, you have got the marriage certificate, then also it cannot be validated, right? Without that ceremony, without that Sat Phere, which is there mentioned in the section 7 of the Hindu Marriage Act 1955, neither it confirms any marital status, nor it provide any kind of marriage, means nor it provide any kinds of obligation on the Supreme Court to accept that marriage, right? So this is what the Supreme Court has said. Means Supreme Court has now said that if the marriage has to have using the Hindu Marriage Act 1955, then section 7 has to be followed compulsorily, means that Sat Phere has to be taken compulsorily, and only after the completion of that 7 steps, marriage will be solemnized. Therefore, using the Article 142 of the Constitution of India, means using this special power, the Supreme Court has said that in this case, complete justice has not been happening. Unnecessarily, couples is seeking for the divorce because the marriage itself has not been materialized, it has not been solemnized. So what is the need to ask for the divorce? Therefore, the Supreme Court has said that the couple which has just registered for the marriage, or they have got the marriage registration certificate, this does not ensure that marriage has happened because they have not done this marriage using the Hindu Marriage Act section 7. So that is not there. Therefore, the Supreme Court has said that this marriage is null and void. There cannot be seeking of divorces on the basis of this kind of marriage. And therefore, the Supreme Court has quashed these divorce petitions and also the dowry related cases which the girl and their family has filed for on the this male and the means their husband and their husband's family, right? So all these things has been quashed by the Supreme Court and said that this Hindu Marriage Act 1955 section 7 is compulsory in nature, right? So what has now happened? What is the way forward? If any Hindu marriage has to be solemnized in real sense, then the couple will have to focus on the real custom and the rituals. Means taking that Sat Phere is very, very compulsory now. Instead of just whining and dining, the couple should focus on this custom. And therefore, section 7 of the Hindu Marriage Act becomes compulsory in nature. Without it, the marriage will not be solemnized. There is need to follow the Supreme Court judgments wherever there will be marriages on the basis of Hindu Marriage Act, because under the Hindu Marriage Act 1955, the couples did not necessarily go for this registration of the marriage, right? That itself, and if they are following the section 7, that itself is considered as a marriage, right? So that Supreme Court judgments has to be followed. And what is the significance of this judgment? This judgment will reduce or eliminate the unnecessary litigation, means unnecessary divorce cases which were coming to the Supreme Court, or which were coming to the different family courts as well as in high courts. So that will not be happening right now, because the Supreme Court has given such kinds of judgments. So this was all from my side in this session. I hope you have understood it. Thank you very much. Keep learning.